Are you a lawyer that's considering taking a medical malpractice case? If so, this video is for you. Mark and I are going to go over this topic with you today and go over a multitude of different things that you could consider before deciding whether to jump into medical malpractice litigation and specifically whether to take a given case. But Mark, you want to get us started with the first thing that someone should consider?
Sure. I think the first thing you need to consider is whether you're willing to absorb the cost and the risk involved. Medical malpractice cases are enormously expensive, some of the most expensive you can take. Maybe a product defect is another type of case like that, but you are going to have experts to prove your case, sometimes multiple experts. They're very expensive, they're very deposition intensive, and so the first thing you have to ask yourself is, am I willing to do this? Because you got to fund the case if it's going to be successful. And so you may want to know, do I have the resources? Am I willing to borrow money if I don't have the resources? Do I need to associate another lawyer who's going to help me pay the cost?
Yeah, and number two for me was going to be consider, especially if you're newer into this field and you haven't handled medical malpractice cases before, it may be a good idea to look around your area and your state and make some connections with attorneys that have handled medical malpractice cases successfully in the past, and consider associating them in on at least the first 3, 4, 5 cases you handle so that you can learn from them, you can shadow them, you can learn, the things that they've done in the past that have been successful, and then help transition you into being able to handle those cases on your own.
Yeah, and one of the things that an experienced med mal lawyer can tell you right off is whether to run away from a case that may seem like a good thing, but people who have had that experience, sometimes through the hard experience of a loss, can tell you what the red flags are in a case, whether this is something that has legs or whether it's something you should just avoid taking in the first place.
Yeah, and the other benefit of hiring or associating an attorney to help you with the case is that can help defer some of the expense that you were talking about, spread it out if you're in an agreement where you're splitting the cost, or it may be where you just refer the case to that attorney and then sit in the background and kind of watch what they do, and then they can front all the cost for you so your risk is lower. And that would be, I think, extremely beneficial if you're just if you're starting a business, you're starting your own practice and resources may be more limited. Then hopefully they won't be so limited 10 or 15 years from now, but starting out, it's just the reality of the situation, and it never hurts to minimize those risks from a business management perspective. Number 3 is, I think anyone who's going to handle medical malpractice cases needs to know that the rules are different. They're not the same as car wrecks and falls and products cases and all that kind of stuff, and those rules are going to vary significantly from state to state. So I would think it would be exceedingly difficult for an attorney to handle medical malpractice cases in all 50 states, and be admitted pro hoc and all that. I mean, it's possible, but it's going to take an incredibly large time commitment to learn the rules of each state everywhere that you have a case. So I would start out in the state that you're in, master those rules, and then if you want to, you could consider expanding into other jurisdictions.
Yeah, and in fact, every state does have its own rules, and for example, in Georgia, we have a specific requirement that you have to have an affidavit signed by an expert and attached to the lawsuit, or your case gets kicked out of court. If you don't know that, you run the risk of filing a lawsuit that's going to be dismissed right off the bat. Another rule we have is we have different expert rules specifically for medical malpractice cases that don't apply to other cases. I'm handling a case in North Carolina right now where there are caps on damages or non-economic damages, and unless you prove gross negligence, we have a gross negligence standard in Georgia for emergency room cases, or at least some of them. So you have to know these things before getting into them. Yeah,
and specifically even statutes of limitations, right? I mean, any attorney knows that's, from a plaintiff's perspective, that's one of the most important things that you have to pay attention to. But those time periods may vary from state to state, and even within a state, the time period for different types of medical malpractice cases may vary. So in Georgia, for example, some cases are 2 years, some cases are 1 year. Some cases that 2-year period may be extended depending on when somebody discovers that the harm has occurred, or they have symptoms of like a misdiagnosis case where they have symptoms of the condition that was not identified at the right time. So you got to really pay attention to that, because not only do you not want to lose the case, you certainly don't want to run afoul of a statute of limitations and then end up on the wrong side of the litigation where you're getting sued for legal malpractice. Number 4, and I think this is the absolute most important thing when it comes to handling medical malpractice cases from a plaintiff's lawyer's perspective, and that's having a good system in place to vet cases, to determine which cases are going to be economically viable, which ones have a reasonable chance of success, which ones are going to be worth the time and the effort and the money that you have to put into it. So realistically speaking, when somebody calls us on a medical malpractice case, the first thing we're going to do is probably look at the damages that are there. Is this a case where the damages and the potential recovery are going to justify the amount of money that we have to put into it, which frankly could be $100, $200, and in some cases up to $300,000, depending on how many experts are involved, how many depositions you have to take, how many experts, the plaintiffs and the defense has, how many consulting experts you have, not just litigation experts, and all of that kind of stuff. But we look at that first, and then if we determine that the damages justify further investigation into it, then we're going to look at potential liability, and there's certain ways that we do that. You want to go into that, Mark?
Sure. And as Joel said, one of the first things I look at is the harm permanent? If it's not a wrongful death case, then is the harm something that has really turned someone's life upside down? But then if I get past that threshold and go to liability, I have a multi-step process that I follow. I'll typically collect the records. I'll look at all the records and see if it passes the smell test just from my review of the records. And I subscribe to lots of medical databases like UpToDate and ProPublica and others that allow me to go research articles on the issues involved to see what does the medical community say, what is the standard of care. Also, I then look at what's the causation. And these medical journals spend an enormous amount of time reading things just to see if I even want a case. Mm-hmm. If I get past that point, then I ask myself, how many experts do I need to consult? And bump it up to the next level. And that system requires sometimes hiring 1, 2, maybe even 3 experts who are going to charge you thousands of dollars to review the case. And so,
and they may say no.
They may say no. I've had plenty of experience spending, upwards of $10,000 or more on a case, and then having an expert say I don't have one. But it's better to find that out at the front end than after you've spent, $200,000 on a trial.
Yep, that's exactly right. So you got to figure out whether it's going to be economically viable, and then from a damages perspective, then you got to figure out, is there liability there, and am I willing to spend the amount of money that it takes to get those experts? And if all of that falls into place, then you may be willing to or ready to file a lawsuit in the case. Another thing outside of vetting from a business perspective is how are you going to get the cases in the door to begin with? I'd say medical malpractice litigation and practicing in that area is less competitive than, say, automobile wrecks. But there are a decent number of lawyers out there that handle them. I'd say there's probably a smaller percentage of lawyers that handle them very well, but they are out there. So you got to figure out, how am I going to market myself to bring these cases in the door to begin with, because that's an additional expenditure. You're spending this money to then potentially bring in a case you're going to have to invest a ton of money and time into. But you need to come up with a good system to build up your reputation in that practice area, so that you're either going to try to get those cases off the street from people that are calling you, cold calling you, or you may develop a system of networking where you try to get those cases from other lawyers, and that's usually going to happen once you have the reputation and you've handled enough of them that other attorneys can have the confidence that you can handle them well. All right, so once you figure all that out, I like to look at a case and say, all right, where could I lose? Like, what area of this case could cause me to lose this case completely? And there's several areas that might not jump off the page and be completely obvious to you. So let's say you go through the stages. You got great damages. You've got liability. You've got the expert saying, absolutely, this was a breach of the standard of care. Well, none of that matters if that breach of the standard of care didn't cause the damages that you're looking at. So rest assured, in nearly every medical malpractice case, even if you think that this error caused these damages, the defense in that causation area is almost always going to have an alternative explanation of causation. And they will have experts to dive into that and say why your experts are wrong. So when picking those experts, you want to make sure that the experts you have are reputable, that their opinions are going to be admissible, and not only that, that whatever venue or county or jurisdiction you're in, that expert is going to be liked by the people that are most likely to be on the jury. So for example, if I'm in a rural Georgia county, I may not want to start looking for experts in New Jersey. And it doesn't mean that the New Jersey expert wouldn't be excellent and smart and qualified and all that, but just the first sentence that comes out of their mouth at trial with a New Jersey accent, if you're in rural Georgia, they're going to have a harder time relating to that expert. So if you can find somebody from your region that will be able to speak on the level of your potential jurors, that's going to be better for you.
Another thing along those lines is you want an expert who's going to shoot straight with you and give you advice and not make you think you have a case that you don't have. So make sure that you ask a lot of great questions of your expert, because, for instance, you may have a case like Joel said where the damages are there and there was negligence that appears there, but the devil's in the details with causation, and there may be some complex medical issue that needs to be explained to the jury. And you don't want an expert who's just going to blow past that and say, well, there was negligence, so you've got a good case.
Yep. Yeah, you definitely don't want experts that's just going to tell you what you want to hear. You need experts that are going to tell you the truth. And that goes for both sides. If you're the plaintiff's lawyer or the defense lawyer, you need experts that are going to tell you, from a defense perspective, hey, you've got some exposure here and you probably should settle this case. Or if you've got a good defensible case that can back that up. Other areas where we typically worry about losses, I know causation is probably the most common. What else can you think of, Mark?
Well, again, it's damages. Is the expert going to appeal? Is your client going to appeal to a jury? It might be that there's damages in a case, but you have a client who can't explain how that's affected their life to any great degree. They might not have family support or friends who could come in and bolster their case through testimony. So you really have to think, if I'm going to spend all this time and all this money on a case, is my client's case going to resonate with the jury in terms of explaining how this has turned their life upside down? Yeah,
there's nothing worse than thinking you have a 7 or 8 figure case and then you go to trial and your client doesn't resonate with the jury and you end up getting a much lower verdict. That's almost as bad as a loss. So let's talk about experts, and we keep going back to this expert thing. But in medical malpractice cases, they are so important. So let's take a scenario where it's come in the door, we've vetted the case, it's a good case, we think all of our elements line up, there's permanent injuries, and let's just say it's a surgical error case where somebody's paralyzed from a spine surgery. When you get that case in the door, Mark, and you start putting your experts together, what types of experts would you look for?
Sure. So if it's a surgical spine case, first thing you would do is look for either a neurosurgeon or an orthopedic surgeon, someone who knows how to do the procedure that was at issue. They may be able to double up and give you standard of care and causation, but you may need a separate expert to talk about causation. But in that case where there's a permanent injury, I'd also probably need a rehab physician to talk about what are the chances of this person getting better over time. And if it is going to be permanent, you might need a life care planner who's going to talk about all the expenses that this person faces in the future. You would need a rehab physician to sign off on the life care plan. And then you would need an economist to say how much that life care plan is actually going to cost in real terms. So right off the bat, you're looking at 4 or 5 experts for a case like that.
Yep, and that's really assuming that the negligence is on the surgeon, right?
Yep.
So if the nurse did something, and you won't know this until you have all the records reviewed, but the nurse may have done something to contribute to this, or the anesthesiologist may have done something to contribute to this, or the radiologist may have missed something in pre-op films that the surgeon didn't know about, and there was a mistake made because of something the radiologist did. So it could go on down the line. So I mean, there's been a lot of cases that we've taken that we thought, okay, Dr. A is responsible, and then we really get into it and start finding out, nope, it's Dr. C who either didn't follow up and address problems timely or didn't identify problems ahead of time, all of these different things. And so you just have to make sure, and this is the next tip, that everything you do is done with a sense of urgency, with a sense of timeliness, because if you don't identify everybody that needs to be brought into the case in time, then you might find yourself on the back end of the statute of limitations with the real liable defendant not having been sued.
Sure, and sometimes I get lawyers who will refer a case to us, and it's 3 or 4 months before the statute runs, and they think this is plenty of time. But you need to collect the records. You need to then review the medical literature. You need to hire an expert. And then if that takes 3 or 4 months in and of itself, you might be out of time. And if you file a suit at the last minute, you might not have the right parties, and then it's too late.
Yep. So that, make sure you have all the experts that you need, and you anticipate all of the ones that you may need throughout the case. So when you're trying to figure out whether, like, how much money you're going to have to put into this case. The next thing is your own time commitment and your staff's time commitment. Do you have the support personnel to help you get through this? So if you've got a case and there's 10 or 15 different defendants, which happens fairly regularly in medical malpractice cases, and you get 10 or 15 sets of discovery in, can you get that completed in time? Do you have the staff to support you to do that? Is your staff competent to handle medical malpractice cases, or are they more used to handling trip and fall and car wreck cases and things like that? And honestly, when you're handling these medical malpractice cases, I tell people a lot, I could probably handle 50 routine car wreck cases in the same amount of time commitment that it takes me to handle one medical malpractice case.
Yeah, agreed. And your example of a 13 or defendant case with lots of discovery, you know, it really resonates, because I'm doing one of those now, and you get discovery responses that are incomplete. This is a hospital case where you have to look into the audit trail, which is the electronic medical record. You have to look into, you know, were the care providers doing secure chats behind the scenes? And if you don't know to look for those things, you're going to miss them. And if you know to look for them, you've got to keep pressing the defendants. We've got another case now where the defense has named 7 experts. One defendant has named 7 experts, and we're deposing them in a month. That's basically my entire month is getting ready for each of these depositions.
Yeah, that's right. I'm glad you brought that up, Mark, because before I got in, well, when I started doing medical malpractice cases, we were just starting to get into electronic medical records. Most of the stuff was handwritten, and your biggest problem was actually understanding and deciphering what's written down on the sheet of paper by the doctor or nurse or whatever. But nowadays, with the advancements in technology, you need to know what to look for and what to ask for in discovery, and know the tricks and tactics that the other side may use to try to shield some of the most valuable information from discovery. And electronic medical records and audit trails and all of those messages between providers and nurses and all of that kind of stuff. I'm going to tell you, the hospitals will go to the ends of the earth to keep you from getting your hands on that, but that is where the gold's at, is finding those messages so that you can box in the providers on what actually happened and who knew what. But long story short, that's one benefit if you're getting started out in medical malpractice cases of bringing in an experienced attorney, is hopefully they will know the things to ask for and the things to look for and the delay tactics and the hiding tactics that the other side may use to keep you from getting the most important information that could blow your case wide open. Finally, what I want to talk about is venue. And if you're a lawyer getting ready to trying to decide whether to take a medical malpractice case, you probably know what venue is from the first year of Civ Pro in law school. But where you're going to bring the case makes a huge difference. If you are in a major metropolitan area with a huge hospital with tons of people that come in and out, and there's maybe 3 or 4 other hospitals in the area, you're less likely to get kind of home cooked, if you will, as opposed to if you're bringing a case against a local doctor, a local medical facility where somebody's, you know, great grandpa and grandma and mother and father and you and your siblings and everybody else went to this doctor or to this hospital because it's the only one within 100 miles. It's a lot more difficult for a jury to swallow that pill that somebody that their family has trusted for generations could make a mistake. So it's something real to consider.
Yeah, I've had experiences in smaller communities where I've gone to try and pick a jury, and half the jury is either working in the healthcare system in the county or related to somebody who is or knows somebody. That becomes a challenge in picking a jury. Even in some of the metro counties, it may be that you have a really high presence of healthcare providers, and you may get a jury panel and the first 6 people in the box are people who are nurses, doctors, whatever, and you have to really consider that when you're picking your venue.
Yeah, that's right. And when you're thinking about venue, don't just throw in the towel right off the bat. Know the venue rules of your jurisdiction, because lots of times, I remember specifically there was one case where we thought we were going to be in Hall County, Georgia, which is a very conservative venue, but right next door is Gwinnett County, Georgia, which is more of a moderate, where you get a fair shake as a plaintiff type venue. And then we had the hospital in Hall County, but the nurse that was the negligent actor in the case lived in Gwinnett County. So in Georgia venue rules, we were able to get the case in Gwinnett County, which made a huge difference in the value of the case and our likelihood of getting the case settled or having a successful result at trial.
Yeah, and I remember in that case, the key thing was finding out the actual name of the nurse and then doing background checks to see where she lived.
That's right. So all in all, if you're considering getting into medical malpractice cases, good for you. Just go into it eyes wide open, knowing that they can be very difficult, they can be very expensive. There's a lot of pitfalls and traps that you could fall into. So our biggest recommendation to you would be, if you're a solo and you get a medical malpractice case and you've never handled one before, go ahead and bring in an experience to help you with that. And maybe for the next 2 or 3 at least, until you feel comfortable handling them on your own. If you're a defense lawyer that's starting to handle medical malpractice cases, you probably are not going to have that problem, because hopefully you're going to be in a big firm and you're going to have partners and junior partners and senior associates that have done this before, that can guide you and help you understand how to properly defend these type cases. But yeah, I think that's about it.
Yeah, I would warn those former defense lawyers, though, that it's a lot different paying for experts when it's you're the one who's paying than it is if your client's the one who's paying. So just remember that.
That's right. Yeah, and if you are a former defense lawyer and you're switching to the plaintiff side, it's also a lot different when you have the burden of proof.
Yeah.
Because as a defense lawyer, you're just poking holes, and if you can win in 1 out of 10 areas, you're going to win the case. As the plaintiff's lawyer, you got to win in 10 out of 10 areas of the case to win it. So keep that in mind, because having the burden of proof makes the case substantially more difficult. But yeah, so we hope this video has been helpful to you. If so, give us a thumbs up, hit that subscribe button, and otherwise we will see you next week for a new topic, because this will be our last video in our medical malpractice series.